On the night of the attack on Philip Saunders, Michael O'Brien and Ellis Sherwood were with Darren Hall attempting to steal cars in the area. Darren Hall later incriminated all three men in the murder of the respected businessman. They were arrested, questioned, released and rearrested before being charged with murder.
Why did you become the focus of the police investigation?
Well, from what I understand, there was a dragnet system and my co-accused Darren Hall did have a criminal record and they brought him in and he was the one who implicated us.
What was he saying about you and Ellis?
He was saying that he was the lookout while me and Ellis went in there and killed him. And then he turned it around and said, no, he killed him and he hit him with a house brick.
In all this time, were there no solicitors involved protecting you and the others?
Just before we got charged, they allowed us to see a solicitor because while we were in the police cells, a police officer alleges me and Ellis Sherwood confessed to the crime talking between the cells.
So you and your co-defendant Ellis are in adjacent cells?
Yes.
A police officer is standing there with you?
Outside, well, hiding behind the cells with a notepad, he reckons, an expenses form, and he just so happened to hear us confessing.
So you've been telling the police consistently that you had nothing to do with it. Miraculously, a police officer says that you're having a confessional conversation between you and your co-defendant.
Yes, he said he could hear us talking and shouting through the doors, yes.
And was that true?
No, it wasn't true.
1999. Something extremely boring happened. A new accounting system was introduced into Britain's post offices. But in the years following, something much less boring happened. Over 1 in 8 of the entire postmaster workforce turned into criminals. Over 900 of them were cooking the books. It took 20 years for a High Court judge to finally declare the blindingly obvious.
Oh my God.
The problem was the software.
It's just doubled right in front of my eyes.
The employees were not actually criminals at all. In 2015, another unexceptional thing happened. The Countess of Chester Hospital neonatal unit had staffing issues and problems with the plumbing. But then a very exceptional thing happened. An ordinary nurse on the unit started murdering the very babies that were in her care. As with the post office, the system itself was demonstrably failing, yet it was the hard-working individual who was unable to clear their once good name. This time, the crimes were committed by just one person, but those crimes were immeasurably worse.
An independent body like the CCRC or something, so, if there's an allegation made against the nurse, that they investigate it and not the doctors. I think something like that needs to be set up to protect the nurses.
Well, during the first trial, I was involved in lots of social media groups and I started speaking up and I was very badly trolled.
Is the landscape of miscarriage of justice evolving? In the past, wrongful convictions often stemmed from individuals simply being in the wrong place at the wrong time, victims of unfortunate coincidence or flawed investigations. Today, it seems that even being in the right place at the right time can put someone at risk, as legal systems and authorities scrutinize and manipulate circumstances to fit a predetermined narrative. Similarly, a prior criminal record was once a common factor in wrongful convictions, as past offences made individuals easy targets for police. Now, paradoxically, it appears that maintaining an unblemished reputation can itself be a risk, where those with impeccable dignity and integrity become threats to powerful interests, making them vulnerable to targeted prosecutions and character assassinations. Miscarriages of justice traditionally required an actual crime to have taken place, with innocent individuals wrongly accused of existing crimes. However, there is a growing concern that justice systems are shifting towards the manufacturing of crime, where fabricated evidence or manipulated legal frameworks are used to create the illusion of wrongdoing where none existed. This transformation raises critical questions. Is the justice system becoming more about constructing guilt rather than uncovering the truth? And what does this shift mean for the future of fairness and due process? Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we ask, is the landscape of miscarriage of justice evolving? It's not that the justice system is failing. It's being deliberately turned into a weapon. Instead of focusing on real crimes with real victims, police and the courts are increasingly being used as tools to serve the interests of powerful organizations or ideological movements. The legal process is no longer just about upholding justice. It's about exerting control. What we are witnessing is a troubling transformation. Cases that should be based on evidence and fairness are instead driven by hysteria, institutional self-preservation, or outright political agendas. Whether it's prosecutors pursuing charges to appease public outrage, institutions using the law to shield themselves from scrutiny, or political actors waging legal battles to silence opponents, the justice system is shifting in a dangerous direction, one that prioritizes power over principle. If this trend continues, the justice system will cease to function as a safeguard for society and instead become a tool of coercion, shaping outcomes to serve those in power rather than upholding the rule of law. For decades, miscarriages of justice were primarily driven by internal pressures within key institutions of the criminal justice system, the police, the Crown Prosecution Service, and the courts, particularly in response to serious crimes where the real perpetrator was not immediately identifiable. Faced with intense public outrage and demands for swift action, police often resorted to aggressive tactics to secure a conviction at the expense of due process. These wrongful convictions were typically the result of flawed evidence, mistaken identity, procedural missteps, or tunnel vision, where police became fixated on a suspect despite contradictory evidence. In many cases, the urgency to restore public confidence and demonstrate efficiency led to corners being cut, ultimately sacrificing justice in the pursuit of closure. But today we are seeing a disturbing shift. It's no longer just about convicting the wrong person for a real crime. Instead, the justice system is being weaponized to fabricate crimes entirely, framing individuals to conceal institutional failures or to serve political and ideological agendas. In this video, we will explore what are the current challenges surrounding miscarriages of justice in the UK and how do they compare to those in the past. To help us explore this shift, we are joined by Michael O'Brien, a victim of a miscarriage of justice, and Michele Worden, a retired NHS nurse. Barbara and I will be posing several questions to them to assess whether our perception of this change is well-founded and to discuss the necessary measures to prevent these emerging forms of miscarriages of justice. Let's begin with Michael O'Brien. Michael, thank you for joining us once again to share your experience and help us better understand the shift we are witnessing in the nature of miscarriages of justice. Your perspective is invaluable in shedding light on these emerging patterns and their impact. We have dedicated an entire video to your story, which is linked in the description below for any of our viewers. But for those who are not aware, could you please share your story about being wrongfully convicted and the circumstances that led to your conviction?
Well, I was convicted with my two co-accused, Ellis Sherwood and Darren Hall, in 1987, a murder of a Cardiff newsagent, and we served 11 and a half years before we proved we were innocent. And the circumstances surrounding that is we were out on the night in question trying to steal a car, for joyriding purposes, and a murder happened not far from where we were. So police used the dragnet system. Anyone with a criminal record was being pulled in, and the other two I was with, Ellis Sherwood and Darren Hall, had a criminal record. So that's how my name became in the frame. And then the three of us, unfortunately, got found guilty the 20th of July, 1988, of killing Philip Saunders, the Cardiff newsagent, and we fought to get ourselves out and cleared.
How did the police pressure impacted your case at the time?
Well, I'll give an example. There was 115 breaches of the Police and Criminal Evidence Act. We were denied access to solicitors. My co-accused done 14 different confessions, and then police honed in on him to say it was us, who killed him, and he was the lookout. You could clearly see there was something wrong with my co-accused, Darren Hall. Very difficult to describe, being a 19-year-old myself, but I knew there was something wrong with him within about 5 minutes of me meeting him. But there was no forensic evidence to link any of us to the crime. The eyewitness said she saw one person, not three. So, everything pointed away from us. So police knew we were innocent from day one. But when you got somebody like Darren Hall, and sadly, there are people who confess to things they haven't done before. We've seen that with the Guildford 4, the Birmingham 6, and many other famous cases. So mine's no different from the norm. Going to today's miscarriages of justice, they are slightly different, but nevertheless, there's still no accountability.
You are absolutely right. The point to note in the shift on miscarriages of justice is first, as you correctly said, before somebody to be wrongfully convicted must have had some sort of encounter with the justice system before. The targets would have been people who had already been in the police radar. But today it seems to be different, isn't it?
Well, yeah, very much so. In the Lucy Letby case, you've got Colin Norris, you've got Ben Geen, and it seems to me like, there seems to be, when it comes to the NHS, when there's things going wrong, they need to have a scapegoat. And when they do, they pin it on innocent people. And that cannot be right. It's a different kind of miscarriage of justice, but nevertheless, it's probably one of the worst I've ever come across in Lucy Letby's case and these other cases I've just mentioned. And, it's got to be stopped at source.
Indeed, is the idea of people actually acting in the course of their duty. For example, I'm thinking the post office postmasters. They are actually in the place where they are supposed to be, and they are conducting the duties that they have been asked to conduct, and nonetheless, they fall victims of the criminal justice system. It's a further hurdle than what past wrongfully convicted individuals had to deal with. What do you think is driving this change? Is it more about the institutions involved, or is it the broader social and political pressure?
I think it's a bit of both, to be honest with you. And you've got to remember that not only is there no accountability, there's no mechanisms in place to safeguard people like Lucy, Ben Geen and whatever. And unless they put mechanisms in place, which I don't mean, it's got to be totally independent from the NHS, like an independent body like the CCRC or something, to, if there's an allegation made against the nurse, that they investigate it and not the doctors. I think something like that needs to be set up to protect the nurses and, people like Ben Geen and Colin Norris and Lucy Letby as well. So, there's a lot wrong with the system.
Your point actually applies also to the post office masters, because in fact, the first point of investigation of their allegations came directly from the post office itself, which had a vested interest in the matter. And therefore, those investigations cannot be in any way considered as independent. So absolutely, you're right there. Are there any aspect of the justice system that need urgent reform to deal with this new type of miscarriage of justice?
Well, as I said earlier, I think there should be an independent body to look at these cases. And with the post office scandal, you cannot have internal investigations when they're serious, when, you're looking at life sentences here, the big sentences, if people are found guilty. You've got to have total independence on these cases. Otherwise, there's going to be more Lucy Letbys, there's going to be more Colin Norrises, there's going to be more Ben Geens. We cannot allow that to happen. And the thing is, the mechanisms to overturn a wrongful conviction are very complex. We know the CCRC are underfunded. We know that they've got a long backlog. It could take 3 or 4 years before we even get a decision on Lucy's case and Ben Geen's case. That's also worrying. Justice delayed is justice denied.
And I think the major challenge that new wrongly convicted people have is that as a base, there is no crime. In most of these cases, there is no crime. So let's say Andrew Markinson, he had in the end a DNA that could exculpate him. But in these cases, you have to prove something that didn't happen, which in itself is an absurdity. So it is a higher hurdle that they have to overcome. Do you agree with this?
I do. It's a bigger threshold. There's no doubt about that. And what you've got to remember, in most of these cases, like Ben Geen's and Lucy's case, it all hinges on expert evidence. What we need to define what is a proper expert, because there are guidelines there. But from what I can gather, and the investigations I've carried out on other people's cases, like Lucy's, some of these experts are not actually experts, and they're allowed to give evidence at the trial and convince the jury that these innocent people are actually guilty. That worries me immensely. If they're not experts as defined by the law, what are they doing in court? Why haven't the judge interjected and stop this from happening? What are they qualified in? Are they qualified to deal with this particular case and these particular issues? If they're not qualified, they have to be heard. It's as simple as that. If you've got a solicitor, I'm not a fully qualified solicitor, but I know the law. No, I couldn't go into a courtroom and I haven't got the right of audience. And rightly so, because I haven't got the qualifications. So why should a so-called expert who haven't got the qualifications be allowed to give evidence in court? It's exactly the same principle.
We have mentioned in many of our videos the urgent need to reform law in relation to expert evidence. And we have also mentioned the possibility of having somebody helping the jury reading expert evidence, so that to ensure that they do not assume that that is a fact, but it is an opinion. And changing slightly a subject, how do you think the media and public opinion has shaped the outcome of wrongful convictions in new wrongful convictions cases today compared to when you were wrongly convicted?
Well, I think it's got worse, to be honest with you, because the simple fact is the police have got loads of access to the media, and once they say they charge somebody, they put out a press release and the media jump on it, especially when it comes to children's deaths or alleged deaths, murders, like in Lucy's case. You got to look at it and think, well, hang on a minute. They're manipulating the media. They shouldn't be allowed. My understanding is, if you have too much publicity, how are you going to get a fair hearing? Within Article 6 of the Human Rights Convention, you're not going to get one. So I would argue that Lucy didn't have a fair hearing because of all the adverse publicity. Nobody even heard a scrap of evidence, and yet she was convicted even before She went to trial by media. That cannot continue. That's wrong. Wrong in principle, wrong in law, and just wrong full stop.
Yes, certainly I can say that the role of media sensationalism did play a prominent part in Lucy Letby. I agree with that, in Lucy Letby's conviction. Do you think there is sufficient public awareness or platform for this new type of miscarriages of justice? And if not, what do you think we should do to raise that awareness?
Well, I think we need people who've been through the system, like myself and Paul Blackburn, by the way, he's done 25 years, he's supporting Lucy as well. I want to stress that. We all need to stick together and make as much noise as we possibly can. And that's why we raise awareness, press conferences, letter writing to the MPs, and raise awareness with the public and publicly speak out like we're doing today. Because this is the only way we can get the message across. Because the thing with the media is it's a double-edged sword, because they convicted the Birmingham Six, as we all know. They've done exactly the same in 1974 with the Guildford Four as well. And they've done the same now in Lucy's case. But them same people now are looking at the evidence and going, oh, I think we made a mistake. And now they're trying to turn it around. Well, if they had behaved properly in the first place, maybe this miscarriage of justice wouldn't have happened.
What advice will you give to individuals wrongly convicted today?
Well, what I would say is, if you're not educated, you have to educate yourself. I had no education when I went into prison. I've never passed an exam in my life. Couldn't read or write properly. You can't do something about it because you need to know everything about your case. You need to write to journalists. You need to write to MPs. And these are the things you've got to do for yourself. You can't expect everybody else to do them. You've got to take the lead as well. Empower yourself to do that. I studied law, and then I started understanding where things went wrong in my case. Then I could challenge it. Until you do those things, it's very difficult to challenge a conviction when you don't know the points yourself. You've got to learn those points. You've got to know your case inside and out. And this is what I do. And this is my advice to anybody who's wrongly convicted, whether it's England, Wales, Scotland, Ireland, whatever. If they're watching this podcast, please get some certificates behind you and some qualifications, because you're going to need them.
That is a very good advice. And how do you see the future of wrongful convictions in the UK? What step do we need to take to make sure that no one else suffers like you did?
Well, it's not just a case of what I suffered. It's like what Lucy and all the others are suffering, because these miscarriages are still prominent today as they were in 1987 when it all happened to me. They're just a different kind of miscarriage. We need accountability. That's the main thing. Nobody has been brought to book for any of these miscarriages of justices. The Birmingham Six, Guildford Four, Cardiff Five, my case, and all the other ones which have come before, Andy Malkinson. Why haven't these police officers been put into prison for what they've done? Why haven't some of the solicitors been pulled up on their shoddy work? You know, it's not just the police you've got to focus on. Then there's the CPS allowing this evidence to be allowed to be used at the trials. You know, so unless we stop it at source, which is the Crown Prosecution Service and the police, sadly, we're always going to have miscarriages of justices like this. So that's the main thing I would say I would like to see, accountability. And this is what I'm fighting for in a number of Welsh cases at the moment.
Michael, that was a fantastic way to conclude my discussion with you. Increased accountability in the criminal justice system would likely lead to greater accuracy in convictions, whether motivated by a genuine commitment to justice or a desire to avoid repercussions. When those involved in the process know they will be held responsible for errors or misconduct, they are more likely to exercise caution, thoroughly investigate cases, and ensure fair trials. This would not only reduce wrongful convictions, but also strengthen public trust in the justice system. Thank you, Michael. That was indeed an inspiring discussion. And I hand it over to Barbara now so that she can take the lead with our second guest, and I'll let her introduce her.
To explore this further, we welcome Michele Worden, a registered nurse, a midwife with a diploma in healthcare studies and a Bachelor of Science in Nursing Studies. She is also a former advanced neonatal nurse practitioner at the Countess of Chester's Hospital neonatal unit itself. Michele, thank you for joining us. Can you introduce yourself and share your professional background and what led you to go into healthcare?
I think I'd always wanted to be a nurse. I started my training back in 1979 in Liverpool, and following qualification, worked for a couple of years as a staff nurse and then decided to become a midwife. And then from that, I really loved neonatal care with the babies. So in 1988, I went to work as a staff midwife on the neonatal unit at the Countess of Chester Hospital, worked my way up, and then eventually went in 93 to Southampton University to do my degree and to become an advanced neonatal nurse practitioner. And subsequent to that, I was then employed on the neonatal medical rota, where I remained for a long time until 2007. And in a cost-cutting exercise, I was served compulsory redundancy, and 7 other senior nurses on the unit, by various means, were dispensed with.
When did you first become aware of the Letby case, and what initially stood out to you?
Well, from the moment of my redundancy, I went to Dr. John Gibbs, who was the clinical lead of the unit at the time, and asked him if he was aware of what the hospital's policy was, that they were getting rid of senior nurses with a wealth of experience and replacing them either with staff who were not qualified, such as nursery nurses, or not replacing them at all. And at the time, his attitude was, it's just a nursing issue, the hospital has to save money, and that's the end of it. Obviously, because I'd worked on the unit for a long time, I knew the staff who remained, and I kept in contact with many of them. And over the years, they started to tell me things. So one of the first things that happened was that they were really busy in 2015-16. One of them described it as like a constant conveyor belt of sick babies. They were short-staffed, they were run ragged, there was too many locums on the medical rota. And then they started to say that various specialists had been called in to write reports, one of whom was the Royal College of Paediatrics and Child Health. And then there was murmurings that potentially this spike in deaths that they had was maybe due to a malicious act. And then by 2017, it was becoming very clear that the finger was being pointed at Lucy Letby. By that time, the Royal College had published their report, and I was given a copy and I read it. And to be honest, I just cracked out laughing because it made it very clear that there were severe issues with the staffing. There was not enough experienced nurses. The consultants were doing 2 ward rounds a week. There was very poor communication between nursing and medical staff. There was too many locums. It was just chaos. And one of their recommendations was that they needed 2 advanced neonatal nurse practitioners. Well, they had them and we were got rid of. But the report didn't read as if anybody had ever said, well, actually, in cost cutting, we've got rid of lots of senior nurses and we did have 2 ANMPs. It just made recommendations. So following on from that, when Lucy was finally arrested and I got told the police were interviewing her, I phoned Cheshire Police and explained who I was. I spoke to a policewoman and said that I had serious concerns. Had she read the Royal College report? At that point, I don't think she'd even heard of it, if I'm honest, and I definitely don't think she'd read it. And the long and the short of the conversation was she wasn't interested. All she wanted to know was, did I know Lucy? Had I worked with Lucy? And did I have any evidence against Lucy? And of course, the answer to those 3 questions are no, no, no. I haven't worked with Lucy. Lucy came after me as a brand new qualified nurse straight out of university. Yet the way she was being portrayed was as a senior nurse. Well, she was only 3 years qualified in 2015. So you can't compare it with over 30 years experience like I had and my other friends who were dispensed with.
Did you follow the trial proceedings directly? If so, in what capacity?
Yeah, I followed it very, very closely. I contacted Lucy's legal team and wrote to them and told them my story and, what my experience was. I never heard from Lucy's legal team at all. I followed it very closely and I became very involved on social media groups of pointing out total inaccuracies that were being stated during the trial. I mean, one of the big ones was that the babies were being portrayed as stable and well. Well, you can be critically ill in intensive care but still be stable. And by definition, if you're in an intensive care unit, you are not well. But it was portrayed as if these babies were all about to go home and they were fine. And that was just a million miles from the truth. And then I was listening to the evidence by the so-called experts, which was nonsense in my eyes. Dowie Evans was talking about all sorts of things like force feeding babies with milk. Well, babies would just puke if you force feed them with milk. That's just what happens. Injecting them with air, all sorts of things were being stated that, in my eyes, as an experienced nurse on a neonatal unit, they just weren't true.
Can you tell us, there were certain things that were portrayed as strange, such as Lucy Letby sending cards to bereaved families. How do you think that was portrayed, and was it fair?
No, it was completely weaponized against her. So as a neonatal nurse, tragically, I've been to babies' funerals. We always tried to send a representative. If I couldn't go, I've sent parents bereavement cards. They said that Lucy had handover notes. A handover note is not a medical record. It is an aide memoir for that nurse on that shift. And I don't believe there's a nurse in the country that hasn't at some point come home with documents. I certainly have documents from my time at work that are over 20 years old. But does that make me a serial killer? And all these things they've said have really destroyed neonatal nursing, because neonatal nurses now are very reluctant to form relationships, which have been the backbone of neonatal nursing, with the families, because they're worried, if I contact them, if I write to them, is that going to be used against me? Is the finger going to be pointed at me? It's awful. I have a friend who works in a very big level 3 unit, and she says at the end of the shift, there's sort of an ethos of make sure you empty your pockets, because, oh my God, if you take anything home, that's going to be used against you. But I don't think there's a nurse or a doctor for that matter. I think doctors take things home, but that doesn't seem to have been mentioned.
What's your personal reflection on this case and its broader implications for the healthcare system?
I think you have to look at what is happening within the National Health Service at the moment. We have had the Donna Ockenden reviews into Shrewsbury and Nottingham. There is another inquiry coming into Leeds. Only this week, the coroner has stated about a baby called baby Ida, who tragically died in the Royal Lancaster Hospital. Now, they had an inquiry in 2015, and they were supposed to have made changes. The coroner this week just said that hospital, despite recommendations and everything else, have just ticked a box and the problems are still there. That is the same in Chester. Chester was no different. The only difference was they pointed the finger at an innocent nurse.
Are you in contact with the current defence team? You mentioned that you contacted the police to begin with.
Yes, I'm in contact with the new barrister, Mark MacDonald, and I have been in contact with some of the experts who Mark has engaged. And I've told Mark my story and I've given him various documentation. And I have been on various media outlets because I think it's very important to get this story out. Another arm of this that is very much talking about, we shouldn't be talking about it, we're just noise, we're conspiracy theorists. But that actually is as far from the truth as you can get. I think it's very important, especially for those parents. And speaking as a parent, They deserve the truth. They need to know what actually happened to their babies. And they need to know that not only for their own peace of mind, but to prevent it happening to somebody else's baby. And at the moment, their lawyers are very much keeping them quiet. They're saying, oh, we're upsetting the parents and the parents think it's terrible. We don't actually know that. That's the lawyer's take on it. And it's recently been revealed that one of the prosecution barristers during the trial, who firmly convicted Lucy, is now working for a group of the parents. Well, that's a conflict of interest, because he's not working to get those parents the truth. He's working to keep the narrative going that she's guilty. And I think the judiciary really need to look at those sorts of things, because that's just not ethical and it's not moral.
There cannot be a clearer conflict of interest there.
Michele, can I ask you something about the Thirlwall inquiry? Were you invited to participate that in any way? And what do you hope this inquiry will uncover or achieve?
I wrote to Lady Justice Thirlwall, again, telling her my story. And I received an email back saying, thank you very much. If we need you, we'll call you. And I've never heard anything else from them. I know that 24 very eminent experts wrote to her at the beginning of the inquiry saying, you need to change the terms of remit because you're not going to be asking the right questions if you're only working on the presumption of guilt. And there's all these other things now emerging. You need to look at them all and ask the right question. Of course, we know that she refused. She refused to allow Mark MacDonald to represent.
To be more precise, it wasn't her, it was the Secretary of State, obviously, because that is his remit. He didn't refuse to change the terms of reference. So in a way, Lady Justice Thirlwall is constrained by the terms. And in our view, that was a big mistake. There have been other inquiries where, in fact, presupposed guilt, and yet they managed to go beyond the guilty verdicts. This inquiry could have done exactly the same and at least look more into concomitant cause. And we know that malpractice was one of them.
Yeah, well, medicine is not an exact science, and they're saying about this spike in deaths. But every hospital will have a spike in deaths. You get clusters of all sorts of things. The post office is a cluster case. They had a cluster of postmasters that they thought were stealing from them, but they didn't look at any of the other mitigating circumstances. And it's exactly the same in Lucy's case. They've had this spike in deaths, but they haven't looked at all the things. And in a way, I actually feel a bit sorry for the police, because the police were faced with 4 consultant paediatricians, 2 in particular, turning up, telling a very eloquent, powerful story, and they took them at face value. And they allowed those consultants to go away, to give them the notes of the babies that they thought were unexplainable. So the consultants were doing the investigation, and then the consultants were also being the main witnesses. So they were the accusers, the investigators, and the witnesses. That just cannot be right. And the police failed.
Conflict of interest, indeed.
Because they didn't do due diligence. And then, of course, you had the expert witness, Dr. Dowie Evans, turn up. And again, the police greeted him, from what I can read, with open arms. And they didn't do due diligence on what was going on. And the same happened during the trial, because Judge Goss received a letter from Judge Jackson, who said, Dr. Dowie Evans is not an expert witness, and be very careful about his testimony. Judge Goss's attitude was, well, we'll let the jury decide on whether he's an expert. Now, how on earth can the jury decide on who is an expert and who's telling the truth? It's how you sell a story. And they absolutely, on the prosecution side, told a fantastic fairy tale story that the jury believed. But there was very little defense given. And the judiciary, I've learned, is very unequitable. So you have the Crown Prosecution Service. It says in the title, we are the prosecutors. You don't have a Crown Defence Service saying, well, we're going to defend the person. You've got completely different amounts of money. So the Crown Prosecution have unlimited amounts of money, whereas the defence is very much reliant on legal aid. And we know that legal aid is not what it should be. The whole thing is totally unequitable. So if you're accused and charged and are going to a trial, the odds are stacked against you before you've even said anything in court.
To add to that, there is also the evidence that you are not shown. So a jury are not shown all the evidence. And in this case, of particular interest, is the fact that there was a dispute between the consultant and Lucy Letby, which formed part of disciplinary, which the jury was not told about. Another reason why the jury might not grasp the full picture.
The jury were not told about the Royal College of Paediatric report. They were not told about the staffing. There was a conflict of interest in the Baby K trial because we know that Dr. Ravi Jairam was at the time in discussions with a film director at Netflix to do a documentary, and yet he was the main witness. So he has a vested interest in her guilt, in Lucy's guilt. But he's not an impartial, unbiased witness then. And certainly we know subsequently his testimony is not reliable. He's, like the other expert, Dr. Dowie Evans, changed his stories. We know from the Court of Appeal that one of the babies, baby C, they were shown an X-ray taken on a specific day that categorically, in Dr. Evans' view, showed that Lucy had injected this baby's stomach with air, but she wasn't even on duty. And then in the Court of Appeal, the prosecution said, well, she must have come in on a day off. How does that work? It's so wrong on so many levels. And I do feel that there is this with the police. I do feel a bit sorry for the police because I think they were just absolutely in awe of these consultant paediatricians, which, let's be honest, a lot of the public really believe doctors. Doctors are supposed to be honest and kind and tell the truth, but nobody questioned them. And they told a good story. And the police have done things wrong, don't get me wrong. You know, they didn't conduct due diligence, which they should have done. But on some levels, you can see why they were absolutely starry-eyed at these consultants.
Michele, you mentioned that, you know, you contacted the police and you contacted the Thirlwall inquiry with all your background knowledge. And you got pushback from it because they weren't interested. What have there been risks or consequences for you personally as a result of your advocacy?
Well, during the first trial, I was involved in lots of social media groups, and I started speaking up, and I was very badly trolled. However, out of what became quite a nasty situation, there were people who messaged me who said, Michele, you're absolutely right, and we need to get this story out. And that's how I became involved with the new defence barrister. So it was very scary, but I think this is so important. It's important for the NHS. It's important for mothers and babies because Chester is not the only hospital with a failing maternity unit. And we know from the Care Quality Commission, they were scathing of the maternity unit. And we know it's happened in other hospitals. I think the judiciary needs to be looked at on how they employ expert witnesses, how information is fed down. I've said about the Crown Prosecution Service. I think we need a Crown Defence Service as well to even the playing field. And I think the jury, in fairness, need to have experts in the jury who actually work within healthcare when there's such complex cases to explain what actually happens. It's so multifaceted, is this, and it's going to have huge repercussions. I just hope that Lucy is exonerated and then there is a national inquiry, because that's what needs to happen. But it needs to be a national inquiry that is open and honest and is not trying to cover things up, however bad they might reveal things. There is this, we've had inquiry after inquiry into all sorts of things. Look at Hillsborough. It took those poor parents who were bereaved over 30 years to get to the truth. And we need to learn that our inquiry system is also not fit for purpose.
Flawed, absolutely. Michele, have you got any concerns about other cases like this one?
Yes, there is currently other nurses in jail, which Michael's mentioned. There's Colin Norris, who actually has been referred back to the Court of Appeal, and I think it's in the Court of Appeal in May. There's Ben Geen, there's Victoriano Chow, there's Lucy. It's interesting that these cases all involve some degree of poisoning with insulin, and I think there needs to be a full report written by experts about the use of insulin information in trials, because from what I understand, Victoriano Chow, Ben Geen's and Colin Norris's have all used flawed insulin data and information. And it's very concerning. And you only have to look, I mean, that's 4 nurses in jail out of the general population. I'm not a statistician, but I think that's pretty high numbers to all be serial killers. These are caregivers. And we know that there is currently 1 nurse on remand from Birmingham. And I think the CPS is sitting back to wait and see what happens with Colin Norris's case and with Lucy's case before they charge her. But I believe she's been suspended and is waiting under investigation, but she's going to be another one. With the Victoriano Chow case, which was at Stepping Hill in Stockport, they arrested a nurse and put her in jail for 6 weeks, Rebecca Layton, and then they realised that she hadn't done anything. And then they turned the camera on Victoriano Chow. And I feel very sorry for him, because he's actually a Thai nurse. He came over to work in the United Kingdom. And I think he's been very much forgotten about, because he doesn't have any family in this country screaming and shouting about him. And I have serious concerns about his conviction. And certainly, you know, before they convicted him, they were saying it was Rebecca Layton. And I don't, from the little bit that I have read about him, I don't think he had a fair trial either. It was very one-sided, and he didn't have any support at all, because he's an immigrant.
Michele, can I ask what policies or structural change you think the NHS could have to sort of prevent similar outcomes, you know, the role of whistleblowing, how these could protect healthcare staff?
I think you have to have an outside agency who's going to come in and look at these cases. You can't have the organisation investigating the organisation, because there's immediately a bias there. There needs to be a completely separate investigatory organisation that comes in and looks at spikes in deaths that can be called, that maybe could have a phone line where parents can phone up if they have concerns. Very often, you know, if you look at the lobbies that have gone on in Shrewsbury, Nottingham and now Leeds, they have all been driven, and Morecambe Bay, by parents. It's the parents who've got together collectively and started screaming and shouting and saying there's something seriously wrong here. So I think there's lots of things that need to change. I think the National Health Service needs to start valuing its nurses, and the government needs to start valuing them. I don't really want to make a political statement, but nurses are not treated, certainly registered nurses, the way they should be. They're very easy to be got rid of because they're employers in the cost-cutting cases. They're being replaced with unqualified staff, and the public, in fairness to them, get very confused. So, you know, a nurse should be a registered nurse or a registered midwife or a registered paediatric nurse or a registered mental health nurse. But then you've got nursing associates. What does that mean? I know what it means. It means that there is somebody with very little training who is being employed, and they're being employed at probably a much lower grade than a registered nurse, and something's going to happen and go wrong. And it's far too easy to not cherish your registered nurses, which is what happened to me and my counterparts, and to replace them with nursery nurses. And it happens across the board. This isn't just about neonatal nursing. This happens in midwifery, with maternity support workers, on the general side, nursing associates, nursing practitioners. We know all sorts of walks of life now that this is happening. But the bottom line is, it's about money. It's totally about
the
money.
name of efficiency. It's this in the criminal justice system has happened exactly the same thing with the single procedure, where the process is no longer representative, or even the people employed in the process are no longer representative of the expertise that indeed is needed.
We need to have a serious look at ourselves in this country on all sorts of levels, whether it's the NHS, whether it's the judiciary, how the police operate and investigate things, expert witnesses. The list goes on, but we do have to change.
It's the systemic view. I believe that most of the time we tend to look at an error which does not necessarily show the full picture. For example, in the case of the criminal justice system, if you go to the Criminal Cases Review Commission today saying I am innocent, they will ask you for one thing that is gone wrong with your case. Now, we all know the miscarriages of justice are never the result of one. It's generally a systemic failure where many things have gone wrong. Unless you got that holistic picture, there is no way you can get the full picture of the case. So indeed, I agree that we need to change and having a holistic view in all aspects of life, adding then the accountability that Michael was talking about earlier on. I think we need to focus on those two. But going back to the expert that you were talking about earlier on, the Law Commission in 2010 looked at the issue of statistical evidence and medical evidence and provided clear directions on what to do and recommended some changes. Unfortunately, the government did not implement any of them, including calling only, for example, in the case of statistical evidence, only certain statisticians who could show certain qualification and expertise in the field. So there you are.
You only have to look at the Lucy case with the statistics, that we now know that the police engaged a very eminent statistician, Professor Jane Hutton, agreed her contract. And then the Crown Prosecution Service, when she started asking questions for more information, suddenly said, oh, we don't think we want to go down this route. She's asking too many questions. Well, that's pretty scary that the Crown Prosecution Service is stopping the police from investigating. And that's the police's job. They are there to investigate.
This issue stems from the case of Sally Clark, where statistical evidence was used, or rather misused at the time. And of course, now the CPS is wary of that and will try not to use statistical evidence to avoid that type of discussions. And in this case, it was thought that in reality, they were not using any statistical evidence, which is probably somewhat accurate in the case of the trial. However, the investigation which preceded the trial lied on principles of statistics, not least the fact that she was in fact said to have been present in all collapses and death. That is a statistical argument.
And they didn't, when they drew up the roster chart, they cherry-picked the babies that they were going to charge her with, which were the ones she was on duty for. We know that she was charged with 7 murders and convicted of 7 murders, but there was actually 17 deaths. And Jane Hutton was asking about the other deaths. Jane Hutton was asking about the hours that the other nurses worked. So we know that Lucy was full-time. She was also working extra shifts. So one week it was documented she worked 60 hours. So if you're working 60 hours and another registered nurse is only working 15 hours, you are going to be on duty more often. And Jane Hutton asked for all sorts of information. She asked for the names of all the doctors to put the doctors on, and the cleaners, and anybody who went into that unit. She asked for the condition of the babies, and they just turned around in the end and went, oh, you're asking too many questions, therefore we're not going to use you. But that is not justice. And it's the same with, you talked about the Sally Clark case. Martin Ward Platt, who backed Professor Roy Meadows in the Sally Clark case, was also the peer reviewer for Dr. Dowie Evans' evidence in Lucy's case. Sadly, he passed away. So then they brought in Dr. Sandy Bowen. Then you have to look at the judge, Robin Spencer. Robin Spencer was at the time the prosecuting barrister for Sally Clark and I think Angela Gannings. And then he was the Court of Appeal judge at Lucy's application to appeal. So it's a very incestuous world within the judiciary. I think there should be something said about, we have to have completely fresh eyes. And there is enough judges and barristers in this country to do that. I don't think they should even be local. Judge Robin Spencer is from Chester. I think it should be a judge from Devon or Cornwall or somewhere.
How can the public play a role in ensuring that justice and systematic reform in cases like this?
Well, I think the media has a great role to play in this. I mean, even before the trial, the media were reporting Lucy's name. They were putting it out that she was the angel of death and all sorts of things. So you can't have a fair trial if all that is already out and the public's perception is that this person is the worst person on the planet. During the trial also, there was a lot of inaccurate court reporting and a lot of things that were really just a journalist's theory. So if you take Judith Moritz, who at the final day when the guilty verdicts came in, she was so excited and it appeared like she was pleased that these were all guilty. But at the end of the day, this is somebody's life, whether they are guilty or not, who are going to prison for a long time. And those parents, they are bereaved. I mean, every miscarriage of justice has victims or a victim. And I think some respect should be shown. Then, of course, in Lucy's case, there was a news blackout. So the world was talking about Lucy's case. And yet here in the UK, nobody was allowed to talk about it. And Sir David Davis used his parliamentary privilege to say, why can't I read this article? This is not open and fair justice when everything is being shut down. And of course, Judge Goss shut the media down because knew he was going to retrial one of the babies. And I think he wanted to try and get a jury who didn't know anything about her, which I think would have been very hard. But then when if you get a jury, which he did, he allowed the prosecution barrister every 5 minutes to say, well, you've got to remember she's got 7 murder convictions. So again, the whole thing is totally warped and biased in favour of the prosecution. Since that trial, fortunately for Lucy, people have been speaking out, eminent people. These aren't conspiracy theories. These are people who have a working knowledge of looking after very sick babies and what goes on within statistics. And yet we've been told, oh no, they're just conspiracy theories, they're just making noise. Actually, this isn't noise. And the only way to overturn a wrongful conviction and to make the public hear about it is to be in the media. So the media can have a very positive effect, but it can also have a very negative effect. And certainly, before any trial, I don't think there should be reporting in the media. I really don't.
The issue of reporting is indeed a live issue because indeed, as we can see in Lucy Letby, had a detrimental effect, having been stopped at the time that it was, because the only narrative possible at that time was then only the negative post-trial report. So in that way, you might think that actually airing every voice in the debate might be more productive than stopping the debate altogether. But certainly I agree, in order to have a fair trial and a fair investigation, prior to a trial, still we should have contempt of court rules that will allow the investigation and the trial to proceed in a fair manner. However, as I said, this has to be used across the board. We can't use a rule in one case different from another. Similarly, we can't use it for prosecution can speak, but defense team can't speak. That's a point that will also need to be included in the discussion of possible reforms.
I think also the issue of anonymizing witnesses as well is very valid. This is not a terrorist trial where I can completely understand why people have to be anonymized. I understand the parents being anonymized, and I completely agree with that, and their babies' names. But the staff that were anonymized two of the consultants who were pointing the finger. Why are they anonymized? If they're saying this person is guilty, they should be brave enough to stand up and say, I'm going to put my name to this. But they didn't. They've hidden behind anonymity. I've never known a trial with so many people who've been anonymized for whatever reason. It's
unheard of, and generally it's for cases where there is a public interest to anonymize, but this is unusual. But the issue of anonymity comes also quite often in the case of false accusations, whereby the accuser is normally anonymized whilst the accused is not. And again, in that case, covering the names of the person who accused could in fact be detrimental and could influence a fair trial. Because imagine if this false accuser has accused somebody else before. Not knowing the name obviously will curtail the opportunity to piece of information coming forward. So again, another issues that should be looked at.
Well, we know in Lucy's trial that one of the doctors who was anonymized, who had been involved in quite a high public case with the coroner, was anonymized because the coroner had absolutely read her the right act on what had gone on with a baby who tragically passed away in 2014. And mistakes happened with that baby. But I don't think that consultant should have been anonymized because she said, I don't want any more adverse publicity. Because by anonymizing her, it meant that the jury didn't know that prior to these so-called crimes of Lucy, that there had been system failures and medical negligence.
Malpractice was one reason, yeah.
So I think it needs very careful consideration before people are anonymised.
Michele, on a personal level, what has this journey meant to you?
Well, I've learned so much. Sometimes I feel like I'm doing a law degree because I have always believed in the British justice system. And when I talk to the friends of Lucy, the nurses that I worked with, I think they're completely conflicted because they cannot believe that the British justice system has got this so wrong. And from it, I've met people like lovely Michael, who suffered a miscarriage of justice. I mean, we all hear about the famous ones like the Birmingham Six, and I knew about Sally Clark, and I knew about the Guildford Four. But there is so many that we never get to hear about. I'd never heard Michael's story. And, you know, I was born in England, I'm British, I'm very proud to be English, but I'm very ashamed at the same time that our justice system has got this wrong, and not just on one occasion, but now I've discovered numerous occasions. And I find it really frightening. And people need to hear the stories.
Indeed, I think making an error in the criminal justice system is easy, and it's not something that happens only in England. Let's make sure that we highlight this issue. It is easy and it can happen. What is wrong is that when an error occurs, we need to recognize, and what we are not doing well is recognizing that error. That is exactly where the problem is, where we don't have sufficient avenues to take our plight. Yes, we got the CCRC, but again, with the CCRC, we have seen what is happening recently, and the issues that the CCRC is trying to please the Court of Appeal rather than hearing the plight of those who claim to be innocent.
It's like Sir David Davis said in Parliament, and he was absolutely right, that the Court of Appeal not accepting Dr. Shu Lee saying his paper was used incorrectly, they said, well, that's not new evidence because you should have been in the trial. But the fact that he wasn't in the trial and the fact the Court of Appeal won't listen to it, that is not justice. That is just not
Might
justice.
be convenient, they said, but it's not justice.
Yeah, and he's right. I think the law is sometimes more interested in the process than in the justice, and that in itself is wrong.
Michael, any views on this issue?
Well, I think my issue is quite simply that we need accountability on these issues, and until we get accountability, we're always going to get these miscarriages of justice. And I don't accept that some of them are mistakes, some of them are deliberate. I think we must mention that. In my case, when a police officer made up an interview note which didn't take place and incriminated me and my co-accused, that's not an accident. A miscarriage of justice in the British dictionary turns around and says that is a mistake. Ours was worse than a mistake. And I think it's the same with many others as well. So, that's where I'm coming from. There's two sides of the coin there, And
I think if you take the Andrew Malkinson case, I was told that the police knew 4 years into his sentence that they had DNA evidence that proved it wasn't him, but they never spoke up. There must be some sort of duty of candor that if you discover new evidence, the police discover new evidence, then they immediately go to that person and say, look, we're now going to support you because we know it wasn't you. But poor Andrew Malkinson, that didn't happen to him. He spent 17 years in jail.
The problem is this, that the law is there in existence and the guidance is there. So a duty of disclosure exists even after a case is concluded. Prosecution and police have a duty to disclose if there is any evidence that comes after conviction that could exculpate you. So the system is there. Clearly, in this case, they tried to say that the fact that there was other DNA present in the victim's clothes was not sufficient because there was not a match on the database. Well, that is clearly not a correct argument because the DNA evidence as was presented to the jury, was that the DNA could have matched 1 in 2 people, basically 50% of the population. But the new DNA evidence, although it didn't identify anyone in particular, it did prove that the DNA was not Mr. Malkinson's DNA, and it was other innocent individual who had been in contact with the victim the day before the rape, the day of the rape, and subsequent to it. So therefore, the story that the jury heard would have been a completely different story from saying that the DNA didn't help the case to now say that the DNA can at least exclude certain people. That is clearly evidence that is important in a trial and should be put back to the jury if the Court of Appeal feels that it's not their responsibility to decide on it, should be put back to the jury for the jury to decide on the basis of this new evidence what should be done. It's not for the CCRC or for the police or for anybody else to decide, well, this evidence actually is not important in the case.
It's
We
totally.
are the stakeholders in the criminal justice system.
I totally agree.
Yeah. I'd like to thank you for inviting me. I'd like to thank Michael because I've learned so much from him, and thank you to you too as well. I will now be telling all my friends about your website, your YouTube channel, because I think it's very important to get this message out. And I just hope that we can get the system changed to prevent this happening to anybody else, because in a civilized country, people do make mistakes, but we should be able to recognize when it's a mistake and to correct it.
And likewise, Michele, we thank you for doing this is an important role that you are playing as part of the public, but also as a nurse in a profession that you cared for a long time. I am sure many nurses will appreciate that, and certainly Lucy Letby herself will appreciate you coming to talk to our viewers about these issues. Michael.
Well, I'm very grateful to you both, and I'm very grateful that Michele has decided to come on this podcast. I'm so pleased that, you know, that everybody is starting to come together and speaking out for Lucy, because at the end of the day, the only way we're going to bring about change is unite. That is the only way we're going to get change, and that means everybody who believes in justice should join the campaign, and let's get Lucy out. Let's push and get these changes brought about as well, because we cannot keep having these conversations 25 years down the line since I've been released, and there's still miscarriages of justice happening like this. It's just not right.
Perhaps closing on that argument, which is a valid one, is one to return to the issue that has been brought up by many parties, that the families believe that this type of debate is disrespectful. I have to disagree with that. Although I have all sympathy for the parents, for victims in a case, we have seen time and time again how those victims are the first one to be let down when a wrongful conviction is revealed. Indeed, Mr. Malkinson referred to the original victim in his crime when he addressed her directly at the Court of Appeal after he was exonerated, saying that the justice system failed not just me, but you as well. And it's important to say that a miscarriage of justice doesn't only affect the innocent person that is wrongfully convicted, but indeed the victims of the original victims of the crime, if a crime exists, or imagine in this case even worse, where there is no crime, a family have been led to believe death and the collapses were because of an action taken by a human being, when in fact it appears now that it was either natural cause, or if it was medical negligence, then that needs to be looked at in a completely different way. And it would have created different feelings, different type of reaction from the parents. But they have to have the double trauma. Yeah. This is a re-traumatized victims.
You know, I've never forgot the victim in my case, and I've always championed the cause. And I can see the two sides of the coin here, but the fact is the families have been misled by the system. That's disrespectful to them too. And what is also difficult is the fact that there's an innocent woman inside and a mother and father who is suffering the injustice of seeing their daughter in prison. We must not forget that side of the coin either. So I can see both sides here. I'd like to think that because I've been involved in miscarriages for now 26 years, and well, 38 altogether since 1987, 26 since I've been out, that my word counts for something. I wouldn't back somebody if I didn't think they were innocent. I would not just jump on the bandwagon as some people do. I truly believe that Lucy Letby is innocent, and this is the reason why I'm here today to argue her points and say we need to get behind her campaign. We need to get her and we need to possible, because the damage miscarriages of justice causes to victims of innocent people. I can say from my own experiences, I'm still seeing a psychiatrist 26 years later since I've been out. You never fully recover. That's the other side of the coin. And the other victims, they're not going to be able to recover until they know the actual truth. So, I'd like to leave it there, but, I just wanted to say, I do feel for the victims. I'm not doing this out of spite. I want them to know that. It's very, very important. I'm not doing this out of spite, just to sort of harm them. I've lost 2 children myself, as I said before, and through no fault of my own. And I know what it's like to lose a child. I know the pain of losing 2 children. So I understand that point of view as well. So I do hope that if any of them do watch this, don't listen to the lawyers, listen to people like us, because you will get the truth.
Michael, actually, if we're finishing on a personal note, I had exactly the same experiences. I've lost 3 babies, premature. My son was a premature baby, so I know exactly the position in which they found themselves. And there is no way I would have allowed myself to discuss this case if I didn't think there was a very important reason. And I'm doing this because my husband was wrongly convicted, and therefore I have a frame of mind to understand both parties. And certainly we don't want to sensationalize the case. We are not here after clicks or anything like that. We are discussing because what we want to achieve here is spoken injustice, is proper reforms that can finally make the criminal justice system respond to people, not to rules. Thank you, both of you, for participating to this podcast.
Thank you.
Thank you.
Thank you.